Welcome back to SCOTUS Oral Arguments and Opinions.
We're back with our oral argument case previews. Today we're diving into Hencely versus Fluor Corporation, a case that could reshape how we think about government contractor immunity during military and wartime operations. But as a quick aside, I hope you enjoyed the Supreme Court oral arguments. I certainly did. We'll continue to host oral arguments. The next slate of oral arguments begins next Monday, November 3rd. We'll, of course, host the oral arguments. If you like our content, please subscribe, rate, and share the podcast. Doing so will allow others to enjoy hearing about important Supreme Court coverage.
All right, let's discuss Hencely. This case generated significant interest from both legal practitioners and policy experts. We're talking about fundamental questions of federal preemption, political questions, contractor accountability, and the scope of wartime immunity.
That's right. For our listeners who might not be familiar, this case involves a tragic terrorist attack at Bagram Airfield in Afghanistan that killed Army Staff Sergeant Ryan Hencely. His son is now suing the military contractor Fluor Corporation under South Carolina tort law, claiming they negligently supervised the Afghan national who carried out the attack. And here's where it gets constitutionally fascinating. Fluor argues that federal law completely preempts these state tort claims because they involve uniquely federal interests in war-making. But Hencely argues that contractors who breach their contracts and violate military orders shouldn't get the same immunity as contractors who follow government directions.
Right, and that distinction is crucial. This case could determine whether the Supreme Court's 1988 decision in Boyle versus United Technologies, which created the government contractor defense, gets dramatically expanded or remains limited to its original narrow scope. Let's look at the question presented to the court and the key legal text at issue. The question presented is, should Boyle be extended to allow federal interests emanating from the Federal Tort Claims Act's combatant activities, exception to preempt state tort claims against a government contractor for conduct that breached its contract and violated military orders?
Now, let me read the key statutory text that's driving this dispute. This is from the Federal Tort Claims Act, specifically Section 2680J, which preserves the government's sovereign immunity for any claim arising out of the combatant activities of the military or naval forces, or the Coast Guard, during time of war. That's fascinating because notice what that text doesn't say. It doesn't mention contractors at all. The Federal Tort Claims Act, by its own terms, only addresses suits against the United States government, not private contractors.
Exactly. And that's a central tension in this case. The FTCA's definition of federal agency explicitly excludes any contractor with the United States. So we have a statute that Congress wrote to govern suits against the government being used to preempt suits against private companies.
The other key constitutional text here is Article 1, Section 8 of the Constitution, which gives Congress the power to declare war and to raise and support armies. Fluor argues these war powers create uniquely federal interests that preempt state law even when Congress hasn't explicitly said so.
Now let's walk through the background facts, because this is ultimately a human story about a father seeking accountability for his son's death. On November 12, 2016, Army Staff Sergeant Ryan Hencely was killed in a terrorist attack at Bagram Airfield in Afghanistan. The attacker was an Afghan national named Nayeb, who worked for Fluor Corporation under a military contract called LOGCAP 4. LOGCAP stands for Logistics Civil Augmentation Program, and it's how the military contracts out support services like food preparation, laundry, and maintenance to private companies. Fluor's contract specifically required them to supervise and escort their Afghan employees while they were on the base. But here's the key factual dispute. According to the Army's own investigation, Fluor failed to follow these supervision and escort requirements. The Army concluded that Fluor's lack of reasonable supervision of its personnel was the primary contributing factor to the attack. The Army investigation found that Fluor had no measures in place to keep local nationals from leaving the work area without escorts. Even more damning, the Army Contracting Command issued a show cause notice concluding that Fluor indisputably did not comply with the key contractual requirements. namely in the areas of supervision of local nationals and adherence to escort requirements. So we have the military itself saying that the contractor violated its contractual obligations and that this violation contributed to the attack. Yet Fluor claims federal law shields them from any state tort liability.
Let's trace the procedural history, because the lower courts have been split on how to handle these contractor immunity cases. Hencely filed suit in federal district court in South Carolina in 2019, bringing state tort claims for negligent supervision, negligent entrustment, negligent control, and negligent retention. Fluor moved to dismiss, arguing these claims raised political questions that courts couldn't decide. The district court rejected the political question argument, finding that Hencely's claims were about Fluor, not military decisions. But then the court granted summary judgment for Fluor anyway, holding that Hencely's state claims were preempted by uniquely federal interests stemming from the FTCA's combatant activities exception. The Fourth Circuit affirmed, but here's what's interesting. They acknowledged that, by their terms, the FTCA's provisions do not apply to government contractors. Even so, they extended Boyle's logic to find preemption based on the conflict between federal and state interests in the realm of warfare.
Judge Haytens wrote a partial dissent finding genuine disputes of fact about whether the military actually retained command authority over Fluor's specific decisions to allow employees unsupervised access or to retain problem employees.
That split reflects a broader circuit split. Some courts of appeals have adopted broad preemption rules for military contractors, while others have limited Boyle to cases where contractors actually follow government directions. The Supreme Court granted certiorari to resolve this question.
Now let's dive into the legal arguments, starting with what Hencely is arguing. Hencely makes three main arguments. First, he argues that the FTCA simply doesn't preempt state claims against government contractors because the statute, by its own terms, only addresses suits against the United States. That's a straightforward textual argument. Hencely points out that for the FTCA to preempt his state tort claims, there would need to be a conflict between the FTCA's text and state tort law. But no such conflict exists because the FTCA addresses suits against the United States, not any contractor.
Hensley's second argument is more sophisticated. He argues that Boyle's uniquely federal interest preemption doctrine is inconsistent with the Supremacy Clause and the court's modern preemption jurisprudence. Right? He argues that Boyle requires a freewheeling judicial inquiry into whether a state law is in tension with federal objectives. That's unmoored from statutory text. Under current doctrine, preemption requires either express congressional direction or a clear conflict with federal law, not judicial speculation about federal interests.
Hensley's third and strongest argument focuses on the factual distinction from Boyle. In Boyle, the contractor followed the government's design specifications exactly. Here, Fluor violated its contract and military orders. As Hensley puts it, Boyle is a defense when the government has directed a contractor to do the very thing that is the subject of the claim. But Fluor asks the court to extend preemption even when the contractor failed to conform to the government's instructions.
Hensley argues that no uniquely federal interest exists where the military itself has found that a contractor violated its contractual obligations. If anything, allowing state tort claims would align with, rather than conflict with, federal policy.
Now let's look at how Fluor responds, because they've got some powerful constitutional arguments too.
Fluor's main argument is constitutional. They argue that Hensley's state tort claims conflict with uniquely federal interests in warmaking that flow directly from the Constitution's text.
Fluor contends that an interest is uniquely federal if it is committed by the Constitution and laws of the United States to federal control, since the Constitution gives Congress and the President exclusive war powers. Applying state tort law to regulate combat operations would interfere with these constitutional prerogatives.
Fluor argues this case presents an even stronger case for preemption than Boyle, because this suit would directly impinge upon the federal government's exclusive war-making authority. They're essentially saying that battlefield operations are categorically different from domestic procurement.
Fluor's second major argument is that the FTCA's combatant activities exception supplies the appropriate rule of decision. They argue that every court of appeals to consider the question has looked to this exception to determine when federal interests in war-making displace state law.
Here's Fluor's proposed test. Preemption applies when there's some connection between the plaintiff's claims and combatant activities during war, and a connection exists between the military's authority and the contractor's actions. That's a much broader test than Boyle's three-part framework. Fluor argues that permitting 51 state tort regimes to regulate military contractors would undermine military effectiveness and federal control over battlefield operations.
Fluor's third argument directly addresses the breach of contract issue. They argue that preemption applies regardless of any alleged breach because the claims still interfere with the federal government's war-making powers. Fluor points out that the Court of Appeals correctly rejected Hensley's breach of contract claim, and Hensley cannot use that claim to circumvent preemption. They argue that allowing tort claims based on alleged contract violations would create an unworkable end run around federal immunity.
Fluor also notes that the Army ultimately decided not to terminate their contract and later awarded them a new contract, suggesting that any alleged violations weren't as serious as Hensley claims.
Now let's look at how the government weighs in, because the United States filed an amicus brief supporting Fluor. They'll also present oral arguments in this case.
The government makes a structural constitutional argument. They argue that the Supremacy Clause preempts petitioners' state law claims challenging a military contractor's combat support actions on a foreign battlefield.
The government emphasizes that regulation of the battlefield involves uniquely federal interests because under the Constitution, Congress and the President wields exclusive war powers in the military context. What's interesting is that the government argues this preemption would exist regardless of whether state law tort claims challenge the contractor's contractual violations or discretionary actions. So they're taking an even broader position than Fluor on the breach of contract issue.
The government also points to Congress's decision to retain sovereign immunity for combatant activities under the FTCA as evidence that Congress recognized the conflicts between state tort regulation and federal war powers.
Looking ahead to oral arguments, what are you going to be listening for?
I'll be really interested to see how the justices react to the practical distinction between following government directions versus violating them. When Hensley's lawyer talks about contractors who breach their contracts, do the justices seem convinced that those situations deserve different treatment?
I'll also be watching for questions about Boyle's continuing vitality. Do the justices think Boyle already provides clear guidance, or do they see this as an opportunity to clarify or potentially limit its scope?
The federalism angle could be interesting too. This court has shown concern about federal preemption that goes beyond clear congressional intent. Do they see contractor immunity as an area where Congress should speak clearly if it wants to displace state law? Plus, given this court's emphasis on text and original meaning, it'll be fascinating to see how they analyze the Constitution's war powers. Does the mere existence of federal war powers automatically preempt state tort law? Or does preemption require more specific federal action?
There's also the practical question of administrability. If the court sides with Hensley, how do lower courts distinguish between contractors who follow orders and contractors who violate them? If they side with Fluor, does that create too broad an immunity for contractor misconduct?
This feels like one of those cases that could have significant practical impact regardless of how it comes out. If the court sides with Hensley, it could encourage more accountability litigation against military contractors while potentially complicating battlefield operations.
And if the court sides with Fluor, it might give military contractors much broader immunity from state tort suits, which could affect incentives for safety and compliance with military requirements. The stakes are particularly high for military families who've lost loved ones due to contractor negligence. This case could determine whether they have any legal recourse when contractors fail to follow safety requirements.
What's also striking is how this case illustrates the broader tension between accountability and immunity in the modern military-industrial complex. Should private companies that profit from military contracts get the same immunity as government officials?
That's exactly right. And different justices might have different intuitions about where that balance should be struck.
We'll definitely be covering the oral arguments when they happen, so make sure you're subscribed. This is the kind of case that could produce some really interesting exchanges about the scope of federal power and contractor accountability.
Thanks for joining us for this deep dive into Hensley versus Fluor Corporation. It's a great example of how military contractor cases raise fundamental questions about federalism, preemption, and accountability in the modern military.
As always, if you found this helpful, please rate and share the podcast. In the next episode, we'll cover RICO versus United States, a case that involves the question of whether the fugitive tolling doctrine applies in the context of supervised release.
Thanks for listening to SCOTUS Oral Arguments and Opinions. Talk to you soon.